Welcome to Immigration News Desk. If you currently hold a green card, or if you are in the advanced stages of planning to become a lawful permanent resident, what I am about to share with you today is not just a news update, it is a fundamental restructuring of how you need to view your legal status in the United States. Because recent developments in early 2026 have sent absolute shockwaves through immigrant communities nationwide, and understanding these changes is no longer optional. It is absolutely critical for your survival in this country. I need you to stay with me through every single second of this video, because the information I am breaking down could literally make the difference between maintaining the life you have built here and facing consequences that you never, ever anticipated. We are witnessing one of the most dramatic transformations of the immigration landscape in recent memory, and the people who are being caught in the crosshairs are not who you would expect. They are lawful permanent residents, people who have worked incredibly hard, followed the rules, and obtained their green cards, who are now finding themselves in a position of vulnerability they never thought possible. For decades, there was a widely held belief, almost a social contract, that once you received your green card, you were safe, you were secure, and unless you committed a violent felony, your status was untouchable. That understanding shaped how millions of people lived their lives. They bought homes, they started businesses, they put down roots, assuming the hard part was over. But what we are seeing now represents a seismic shift where immigration enforcement is piercing that shield of permanent residency. This is not speculation. This is not fear-mongering. This is based on multiple confirmed sources familiar with internal policy guidance at the Department of Homeland Security, indicating that deportation priorities have been significantly expanded to include categories of lawful permanent residents who previously would have faced zero risk of removal. We are talking about individuals who have held green cards for 10, 15, even 20 years, people who pay taxes, who have U.S. citizen children, and who consider America their only home. The magnitude of this change has immigration attorneys who have practiced for 30 years saying this is the most aggressive enforcement shift since the laws changed in 1996. What makes this particularly terrifying is not just the rule change, but the coordination between agencies. We are seeing unprecedented data sharing between USCIS, ICE, and Customs and Border Protection. According to official statements from senior DHS officials, the administration's new position is stark and uncompromising. Lawful permanent resident status does not provide immunity from immigration law enforcement. The argument is that the law has always allowed for the deportation of green card holders, but that enforcement was previously too sporadic or lenient. Now they are moving toward a systematic, methodical review of green card holders to see if they fall under any deportability grounds. To give you a sense of the scale, internal audits conducted in late 2025 reportedly identified tens of thousands of cases where green card holders had unresolved legal issues that are now being flagged for potential removal proceedings. These are not terrorists. These are regular people whose files, when examined under a microscope, reveal issues that were overlooked in the past. If you have gone through the green card process, you know how grueling it is. The forms, the fees, the biometrics, the interviews, and you assumed that once you had the card, you could breathe easy. That assumption is now dangerous. The new guidance places a heavy emphasis on mandatory referrals to ICE when red flags appear during routine interactions. Think about that. You file a Form I-90 to renew your expired card, or you file an N-400 to become a citizen, or you petition for your spouse, and that act of filing a form triggers a background check that ends up putting you in deportation proceedings. This is the naturalization trap that so many people are falling into right now. They apply for citizenship thinking it is the next logical step, not realizing that they are inviting the government to re-adjudicate their entire history from day one. So, who is actually being targeted? The first and most critical category is green card holders with criminal convictions. But let me be very specific here because this is where the misconception lies. We are not just talking about murder or drug trafficking. We are talking about crimes involving moral turpitude, or CIMTs. This is a legal term that includes a vast array of offenses, including things like shoplifting, domestic disputes, credit card fraud, or even passing a bad check in some jurisdictions. In the past, if you had one of these minor offenses from 10 years ago, officers might have used their discretion to let it slide. That discretion is evaporating. They are looking at old DUIs, particularly if there are multiple, or if there is an aggravating factor like a child in the car. They are looking at drug offenses that were dismissed in state court. Remember, immigration law is federal, and federal law does not always recognize state expungements. You could have a clean record in the eyes of your state, but be deportable in the eyes of immigration. The second major category facing this crackdown involves travel and the concept of abandonment of residence. Immigration law has always said you must maintain your primary residence in the U.S., but enforcement was loose. People would go back to their home country for 6 months, 8 months, stay with sick parents, and come back. Now, Customs and Border Protection officers at the airports are armed with clearer directives to scrutinize green card holders returning from extended trips. If you have been gone for more than 6 months, the burden of proof shifts to you to prove you didn't abandon your life here. If you have been gone for a year without a re-entry permit, the risk is massive. Officers are asking to see your lease, your utility bills, your employment records. They are pressuring people to sign Form I-407, which is a voluntary abandonment of the green card. Never, ever sign this form at the airport if you want to keep your status. Demand to see a judge. But the fact that they are pushing this shows the aggression of the new policy. The third category, and this one is heartbreaking, involves people who obtained their green cards through marriage. We are seeing a reopening of files where they are looking for past misrepresentation or fraud. And it's not just about whether your marriage was real. It's about whether you told the truth on every single line of every single form you ever submitted. Did you leave out a previous address? Did you fail to mention a job? Did you omit a prior visa denial from 20 years ago? In the past, minor errors were seen as clerical mistakes. Under the current framework, they can be weaponized as material misrepresentation, which is a ground for stripping you of your green card. This is why historical paperwork is your lifeline. You need to know exactly what you told the government 5, 10, or 15 years ago. If you contradict yourself now, even accidentally, it looks like a lie. This scrutiny also applies heavily to conditional residents removing conditions. If you are filing Form I-751, expect a grueling review. Even employment-based green card holders are not safe. If you got your green card through a job and then quit that job 2 weeks later, they are coming back to ask if the job offer was ever real or if it was just a vehicle to get the card. That is considered fraud. The broader impact of this is that processing times are slowing down because officers are spending more time digging for dirt than approving benefits. Requests for evidence or RFEs are becoming incredibly invasive, asking for 15 years of tax returns or travel history. Legal experts are calling this the end of discretion. In the past, an officer could look at your file, see a minor mistake, but weigh it against the fact that you have been here for 20 years and are a good person. That human element is being stripped away in favor of rigid adherence to the text of the law. This creates an atmosphere of terror because it means that living a good life for the last decade might not save you from a mistake you made in your 20s. Advocacy groups are screaming that this will lead to the separation of families, with U.S. citizen children left behind in foster care or forced to leave their country because their breadwinner parent was deported for a decade-old paperwork error. But I want to pivot here, because while this information is heavy and it is frightening, panic is not a strategy. Knowledge is your armor. If you are watching Immigration News Desk right now, you are already ahead of the curve because you know the threat exists. There are practical steps you must take immediately to protect yourself. First, do not file any new application, no renewals, no citizenship, no family petitions, without having a qualified attorney review your entire file first. You need to know what the government knows. We recommend filing a Freedom of Information Act, or FOIA request, to get a copy of your own immigration file so you can see if there are any ticking time bombs in there before you alert the government to your presence. Second, be incredibly careful with international travel. If you have any criminal record, even an arrest that didn't lead to a conviction, consult a lawyer before you get on a plane. When you re-enter the US, you are technically asking for permission to enter again, and that is when they catch you. There is also a silver lining here for the proactive. Because the rules are becoming clearer, you have the chance to clean up your record before they come for you. If you have an old conviction, talk to a criminal defense lawyer who understands immigration about post-conviction relief to see if you can vacate the judgment. If you have a paperwork error, see if you can file a waiver. There are waivers available, like the 212H waiver for certain crimes or the 237A(1)H waiver for misrepresentation, but you need to apply for them affirmatively. We also have to look at the political landscape. These policies are administrative, meaning they come from the executive branch. They can be challenged in court, and lawsuits are already being prepared to argue that this retroactive enforcement violates due process. The courts may step in and say, no, you cannot deport someone for a rule you weren't enforcing 10 years ago. So the fight is not over, it is just beginning. But you cannot rely on a future court ruling to save you. You have to protect yourself today. The key takeaway is that the era of flying under the radar is over. The government's databases are connected. Digitizing old paper files is a priority, and they are looking for reasons to reduce the immigrant population. It is crucial to understand that not every green card holder is in immediate danger. If you have a clean record, you pay your taxes, you haven't stayed outside the US for long periods, and your initial application was 100% honest, you are likely fine. But you need to shed the complacency. You need to verify your history. And most importantly, you need to ignore the rumors from your neighbor or your coworker. Immigration law is incredibly fact-specific. What worked for your cousin might get you deported because your facts are slightly different. This is why channels like Immigration News Desk are vital. We are here to filter out the noise and give you the raw, unfiltered truth based on policy manuals and legal precedents. We are seeing a lot of misinformation on social media right now. People telling you to sell everything and leave, or telling you that you are definitely going to be deported. Do not listen to fearmongers. Listen to facts. The fact is that enforcement has tightened, but due process still exists. You still have the right to an attorney. You still have the right to a hearing. They cannot just put you on a plane tomorrow without a process. But you want to avoid being put in that process to begin with. Looking ahead to the rest of 2026, we expect to see more notices to appear being issued by mail. This is how it starts. You don't get arrested at your house. You get a letter telling you to show up in immigration court. If you get that letter, do not ignore it. If you miss your court date, you get an automatic deportation order in absentia, and then you truly are a fugitive. If you move, you must file Form AR-11 to update your address within 10 days. This is a law that is rarely enforced but is now being used to catch people. If they send your court notice to an old address and you don't get it, that is your fault in the eyes of the law. As we navigate this complex and hostile environment, remember that you have contributed to this country. You belong here. But belonging is something you have to defend legally now. The path forward requires vigilance, preparation, and strategic action. Do not apply for citizenship just because you think it's time. Apply because you have vetted your case and you know you are safe to do so. Do not travel just because you need a vacation. Travel because you know your re-entry is secure. In conclusion, what we are witnessing in 2026 is the end of the honor system in immigration and the beginning of the verification era. The government is checking its receipts. The expansion of deportation priorities to include lawful permanent residents is a policy choice that prioritizes enforcement numbers over community stability, but it is the reality we are living in. By watching this video, you have taken the first step out of the darkness and into the light of awareness. You now know that minor crimes matter, that travel matters, and that old paperwork matters. You are now empowered to check your own files, to consult with counsel, and to make smart decisions. Thank you so much for trusting Immigration News Desk with your time today. I know this was a heavy briefing, and some of it was difficult to hear, but we believe in treating you like adults who deserve the truth, not sugar-coated platitudes. If you found this deep dive analysis helpful, Please hit that subscribe button and turn on notifications because the situation is fluid, and we will be back with updates as soon as new court rulings or policy memos are released. Share this video with your family, your church groups, your community organizations, because the more people who know their rights, the harder it is for the system to steamroll over us. Stay strong, stay legal, and stay informed. We will see you in the next update.